And I want to start out by saying, first of all, that this webinar, we're going to go into wage and hour compliance and meal breaks and all that stuff. And I guess I'll put up my legal disclaimer while we're here, while we're talking about this, so you can read through that. But this is in no means an exhaustive labor law seminar. I don't think that we could do that all in time. This one is long enough and it's in depth enough. So there might be some very specific wage and hour laws that maybe I don't touch on today, but I want to make sure that that we know they're out there. So if you have a question at the end, you can go ahead and bring that up. If we didn't touch on something and you'd like more information, certainly email me or Anna, and we can help you with that. But we want to go through the really big stuff right now for this webinar, to make sure that you at least, let's knock the big ones out, and then we can focus on some of the smaller ones that are out there. They're all areas that are difficult and challenging to comply with, and we're just glad you're here to try to make that effort. We're in California, right? So we really don't have a choice as employers. We've either got to take it on and take the challenge on, or go find something else to do in business without employees. So with that, you can see our legal disclaimer. This is not legal advice. We're going to go through everything that we can, and give you as much advice as we can, but please check with us or an attorney before you make any decisions on any specific laws. And I want to say one other thing too. This is a long lot of information in this webinar. I sent out slides last night. If you didn't get that, I'll shoot you one. In fact, I can probably put one in the Q&A. I don't think I can do two things at once here. So follow along. I'll get you the slides right after if you didn't get those. But we're not going to touch on every single line. I'm going to try to go through it as much as I can and focus on the details. If not, we'll be here till 11 o'clock this morning, and I want to be respectful of your time. So with that, we'll get started because it is sort of a long webinar. If anybody has any questions to start out with, please let me know. But I'm going to go ahead and jump in today. Okay, so what we're going to talk about today, and it's a long list. Do a quick introduction. We're going to just kind of understand an overview of wage and hour laws from our perspective. We're going to look into PAGA. We've talked about that our last webinar. You can catch that video on our YouTube page if you want more in-depth information on that, but we're just going to touch on it. We're going to talk about employee classifications, overtime, regular rate of pay, meal and rest break compliance, timekeeping, payroll accuracy, final checks, paid sick leave, wage statement requirements, handling wage and hour disputes if complaints come up or PAGA claims come up, and then what are like some compliance best practices, and then finally an action plan for 2025 stuff for you to think about. So with that, let's jump in. We'll do a quick introduction. And listen, navigating wage and hour compliance is California's never been more critical. With PAGA and some of the challenges in the labor market where employees have gotten used to not working after COVID, they're finding every excuse to go after employers for minor technicalities. And it's not that they're evil people. It's just unfortunate that it's gotten this way. And it's not everybody, but it's happening. And we've got the most complex labor laws in the country. We've got payroll in other states, and we know. And it's not just about avoiding penalties. It's about protecting your business and your employees, because we want to do what's right. With PAGA, there's opportunities for some pretty heavy liability. With PAGA reform, it's been reduced, and we'll talk a little bit about that. But if you take proactive steps to ensure compliance, you can really limit the damage and limit, whether it's intentional or accidental. And during this presentation, we want to break down some of that and try to help you through it. So we'll provide some actionable steps on every area. Okay, with that, we'll continue on. Thanks all. Thank you all to you, the folks that have just jumped in. We had another 5 or 6 or so jump in just now. So welcome. Thank you guys for being here. We're going to jump in. Oh, this was actually a video. I could have had a video playing during this. I set that up, but I don't know who this guy is, but it's cute. Okay, we'll move on. Okay, so just let's understand wage and hour laws in general. And if you guys understand, we're a payroll HR company, probably way more HR focused than most payroll companies. That's why our clients stay with us so long. We really, really realize the challenge of wage and hour laws in the country and in the state, and we want to make sure we help you to deal with it. So obviously I said this, they're more complex and they're always changing. So what you knew last year may not get you through this year. PAGA reform has mitigated risks, but compliance and proactive action is critical. Non-compliance can lead to lawsuits, penalties, wage theft claims, and just overall, dissatisfaction with your workplace. This session is going to help you protect your business and do right by the employees. That's our goal. Listen, we love people, we love our people, and we want to do right by them. If the state says we got to do something, then by gosh, we're going to do it, and we want to try to make that as easy as possible for you. So staying ahead of evolving wage and hour laws, it's essential for protecting your business and having costly penalties, legal challenges. And as I said in my PAGA reform webinar, it used to be years and years ago, you had a little minor, problems with an employee overtime, didn't get their paycheck on time, whatever it was. You went to the labor board claim. We drive up to, downtown San Bernardino or Riverside to the county or state offices, and we would sit down and we'd mediate a solution. There was rarely any major penalties. It was pretty much, hey, let's get everybody through this. And then PAGA came out in 2015 or whatever that was. And it changed everything because now it gave employers and employees much more power to go after you as an employer. So anyway, that's changed a lot, and that's why we're here today. So let's talk about the basics, right? So California Labor Code is way stricter than federal wage and way stricter than just about any state that I know of. We're going to cover minimum wage, overtime, meal, rest break, accurate payroll records, things of that nature. It's our responsibility, right? We've got to pay people correctly. We've got to track their hours accurately, which is something we'll talk about later. And we've got to maintain compliance with the laws. We don't really have a choice, as I said. Employee rights, they have a right to fair wages, breaks, being classified properly, not put into a salary position when they're not necessarily qualified. And by proactively understanding and adhering to these regulations, employers can not only protect themselves from penalties, but also foster trust, productivity, and culture of integrity. I think that's important. We've talked a lot about workplace culture, and that's where it starts. Integrity and transparency is where, if you don't have those foundations in your business for culture, then you don't really have a really good culture. Excuse me, I don't mean to enjoy my coffee on your time this morning, but that keeps me going. Okay, so let's talk a little bit about PAGA. I told you I'm not going to get into it deeply, but what is it and why was it reformed, right? So PAGA is a Private Attorneys General Act, which allows employees to sue their employers for labor violations on behalf of the state. Well, how many employees that can sue without an attorney, right? So attorneys get involved and they can see dollar signs because the majority of the claim, the attorney will take 25% off the top of any settlement that is results from a PAGA claim. Then the employee and the state split that settlement 75-25. So the employee gets 25%, the state gets 75%, and the lawyer gets 25% of that before anybody else gets their cut. So it obviously incentivized labor attorneys to go after these claims, and they went after it very, very aggressively. So there has been some reform, and it was reformed in 24 to reduce the frivolous lawsuits, much like the ADA used to be, limit the excessive penalties, and really provide you with a much better opportunity to fix things first, like proactively, but also even fix them when you are made aware of a problem, right? If somebody files a complaint. So what are the key changes? So basically it's limiting penalties for minor and unintentional labor violations. Woohoo, that's the biggest thing, right? Technical, little 1 minute late on a lunch break or short, could cost you tens of thousands of dollars, and it was an unintentional break that the employee just clocked in early. So those kind of things are being greatly reduced, but you've got to be able to track it. I was on the phone with a client yesterday, and I basically, and I understand her thinking. There's nothing wrong with this thinking, where it's like, well, why can't I just track my stuff on paper, have the employee fill out what time they took for lunch? Well, the employee could say, well, gee, I had a job I was working on, and I had to write down my lunch so that I took my lunch, my meal break, even though I didn't really have time. So it really wasn't true. So they could still come after you if you're not tracking it electronically, and make sure you do it. So we'll talk about more of that later. I get ahead of myself. So there's a streamlined claims process, right? So there is a process that you follow. The state's going to help you through that. There's certified compliance programs. This particular webinar that you're on right now, from all that I can tell, is a certified compliance program. Okay. I will send out a notice or a certificate of completion from if you've attended this webinar, and that will be something that you could show if anything ever comes up and say, hey, I have been through a compliance webinar and I understand the complexity and all the laws, and we're doing these things to help that. So this is the first step in the process. Labor Commissioner has much more authority now to kind of jump in and resolve claims ahead of time. We haven't seen it happen yet, so we don't know how it's going to actually work out, but at least the process is there. So how can you take advantage, right? And we already talked about again this last month, but implement the certified compliance programs, conduct regular audits, right? So making sure, going back and looking, hey, did we miss anything? Did we not pay somebody on time? Did we miss a meal break? Putting things in proactively, which I can help you with as well. We'll talk about, we'll sort of make that process easier. But we want to train managers on wage and hour regulations and how to dispute when issues come up, or how to manage disputes. And what this particular webinar is going to be converted into an online training course. Expect that to be done in March. It does take a little while for us to convert these things, but we'll put this into a course with questions and a certificate of completion, so that will be available to your managers and everybody in your company. So another thing is resolve issues eternally before they escalate, right? So having open door policy and engagement with your employees, that if they have an issue, they should feel they can come to you and talk about it. You get a chance to kind of do that ahead of time. So that's just again, that's a general overview of PAGA. If you were not on the webinar in February, please go to our YouTube page, Infinium HR, and you can check that out, and that'll help you understand it more in depth. Okay. So we need a quick coffee break. Let me get to the next slide. Okay. So now let's talk about employee classification. So this involves, several different things, right? Where there's hourly non-exempt, right? So that's your general hourly position. They're not a manager. They've got a defined hourly rate. They get hourly pay. They track their hours. Anything over 8 obviously is overtime. Over 40 is overtime. They're subject to meal and rest breaks where applicable, right? So if they work enough time, we'll talk more about that. An employee should be tracking all hours using some sort of a time card or electronic device. Again, I'm sort of biased against paper tracking of time. If you're not using timekeeping, it is worth it to the extra effort and maybe a little bit of cost to track hours electronically. They're salary exempt, right? They've got a set amount per pay period or per year. They've got to be eligible to be this. So I can't just say, hey, I want to make you salary because it's just easier for me, right? So I've seen businesses do that. They've got to be a manager. Or if they're not a manager of 2 or more people, they've got to have administrative control, right? So that means that I may have a controller in my business, or a head of marketing that really manages a major sector of my business, but doesn't have any employees. They can qualify, perhaps. Maybe a salesperson with an outside salesperson eligibility, or professional computer technology, things of that nature. So they've got to fit that eligibility. They can have no deductions for partial time off. So if that employee takes a half a day off, or a day off, or 2 days off during the week, they got a sickness, a doctor, or whatever it is, you can't dock their pay, right? Their pay is if they've worked any part of 1 week, you've got to pay them the full salary. Okay, so that's tricky. Definitely get some help before you cut any or deduct any pay from salaried employees. There's no need for them to track time. We've had employers ask us, should we track their time? Can I track to see how many hours they're working? You know, maybe on a project basis you can do that, but you've got to be careful, because if you dilute that salary non-exempt or salary exempt criteria by making them track hours, then a judge could look at that, or an attorney could look at that and say, well, they really weren't salary. So you got to be very careful with that. You truly want somebody that's salary. And then finally, the minimum exempt pay for that right now is 2 times minimum wage, which is currently 68,640. So you would have had to have made that change at the beginning of this year. If you haven't, please do so. But you know, this minimum wage thing, we're not going to talk too much about that today, because everybody knows what that is. It's $16.50 an hour for all businesses, unless you're in specific counties or healthcare and it's higher, or you're a fast food restaurant chain kind of thing. But you know, when you have this minimum wage increase, it increases everybody. Everybody needs to move up the ladder a little bit. So it does have an impact on your whole business, whether or not you have minimum wage folks or not. And then there's hourly plus, I'm going to say plus commission. We can call it plus piecework of some sort. Typically, it might be a sales position, or it might be for somebody that's production, right? So if I have an HVAC business, I do air conditioning, and my guys make $20 an hour, but they go out and if they get a little spiff on anything that they sell, right? So they sell some parts, or they perform a maintenance and they upsell that client and they get a little commission on that, that's a commission. If I've got a mechanic, and that mechanic does a job, and I used to pay them the old way, right? I used to be able to pay them flagged hours and a very complicated, you know, piecework kind of thing. Then now I want to give them a base hourly rate plus pay them a percentage or whatever of a particular job that they did, right? So whether it was changing a radiator or whatever, that would be piecework, right? So employees can work full commission, like you can have somebody 100% commission if 50% of their job is in outside sales. If they're an inside salesperson, then that doesn't work unless, you know, a whole bunch of their commission is made up, or their pay is commission. So that's different. You cannot do piecework anymore. I cannot pay an employee by the jobs they do, the number of jobs they do, a percentage of what they do. You can't do that anymore in California. Talk to me if you are, because we want to get rid of that form of pay. And employees may receive hourly pay plus commission piecework. If it's paid as an hourly rate, we've got to factor in the regular rate of pay, and that's something we'll talk about in a little bit. Okay, again, I told myself I wasn't going to go into every single detail, but some of these things I will, so I apologize. I don't want to keep you guys over an hour today. So again, independent contractor is another classification. We all know that under AB5, it's presumed that a worker is an employee unless they can meet 3 of the following rules, right? Either A, they have control and direction of themselves. They're free of control and direction. They can do whatever they want within the business. Well, most workers, we can win that one, right? We get the A1. This is where a lot of companies fail. So they say, well, I want to use them as an independent contractor. They do work for other people. Like if I look at the third one here, they're doing it as a trade or as a side job, or they do it for multiple companies. Okay, so I could probably comply with A and B, or A and C, excuse me. But B is is it outside the usual course of my business? If my business makes widgets, right, the widget thing, and I have this guy at home in his garage and he's making widgets for me, but I give him, he does it for other people, and he's on his own. Well, I fail B, right? So he's making something that my business does. So that doesn't work. So you got to be real careful. If the worker fails any 3 of those criteria, they've got to be an employee. So it's very, very difficult to have somebody that's really related to the core function of your business these days be an independent contractor. Okay, so hopefully that's good for you guys. Moving on. So what are action steps? Just audit your roles and pay structure. If there's anything that's outside the box, right? The box is a simple hourly person that makes more than $16.50 an hour. If there's anything outside that box, just make sure they're in good shape, that they meet all the laws. verify exempt, non-exempt status. You got to meet the thresholds. They've got to, you know, they've got to qualify, as we talked about. Non-exempt employees must be receiving overtime and breaks and all that. Go through that. Check your commission employees. Confirm that you have a written agreement in place, that you're meeting minimum wage compliance and overtime calculations. You can get caught up in that if you got a commission salesperson and they're really not earning their keep, and they're not even making minimum wage, then that might be a problem. So something to look at. And then apply that ABC test to any contractors that you got. Do they have anything? Are they doing anything within your core function? And even if it's sort of related, you got to be careful. Take some time out to look at that. And then update your policies, any contracts. Make sure, again, you have commission agreements in place for salespeople. And then, review your timekeeping practices. Make sure that hourly employees are truly tracking all their hours, and you've got some record of that. And then finally, this is really important, and this is where I think this webinar will come to help you. Train your managers on wage and hour laws. You as a business, if there's any business owners on the webinar today, or if you're a manager, there might be a disconnect between what management wants and what's happening at the lower level, or what owners want and what management is doing. So make sure that they're trained, make sure that they know exactly what's expected within the wage and hour compliance laws, and that way you could be safe. And then consult legal HR experts before you do anything. That's what we're here for. But obviously attorneys can help as well. They're just more expensive. Okay, so let's talk about overtime rules and regular rate of pay. This is a fun one. This is a big one, but understanding these laws is very, very, it shouldn't be so difficult, but it is. It's not as difficult in other states. A lot of states don't have the 8-hour a day thing, but I think we want to make sure that we're complying. So what are basic overtime rules? And listen, I know you guys, everybody knows this, right? This stuff, but we're going to go over it. I won't go through it in huge detail, but obviously it's time and a half, 1.5 times regular rate of pay for hours worked beyond 8 or beyond 40 hours in a week. This only applies to non-exempt employees. Double time pay for anything over 12 hours in a single day. And then 2 times rate for, is it, I may have that wrong. Somebody correct me if I'm wrong, but is it 10 hours a day? I might have put that wrong. I think it's 12. Somebody correct me if you're on there. 2 times regular rate for anything over 8 hours on the 7th consecutive day. So if you are working, more than 8 hours, more than 6 days in a week, they go on to the 7 in the same work week, then you've got to pay them that double time rate. You got to make sure your work week is structured so that it's worth. So if your work week is Monday to Sunday and the 7 day goes from Tuesday to Monday, that might not apply because Monday is in a new week. So be very careful about how you structure your pay period and your days. Okay. And it is 12 hours a day. Forgive me. Okay. Yeah. So who qualifies this? Obviously, hourly folks. Non-exempt employees must be paid overtime. Exempt employees do not qualify for overtime, and that's basically it. So overtime's pretty basic, pretty simple. But we now have this regular rate of pay, which has been here for about 4 years now. So what is a regular rate of pay? So this is hourly wage plus any non-discretionary bonuses, right? So I should say discretionary bonuses. I should say, there's a lot of information in these things. If you have a discretionary bonus, right? Discretionary bonuses, I get paid to do a certain amount of work or complete a project, or it's a commission, or it's a bonus because we hit our profit numbers this month, but it's something that is discretionary. I think, and I do have that wrong. I apologize. Discretionary bonus is when you've set something in place for that employee, a goal, an objective for them to hit, and then they get their bonus, right? A non-discretionary bonus is, hey, it's Christmas time and I just feel like giving everybody $500. That's a non-discretionary bonus. It's something that you've come up with. So that is not included. So let's make that real clear. So it might be commissions or piecework, as we talked about. Split differentials, that's a fancy word for saying multiple pay rates. So if I have an employee that works two different types of jobs, there are two different pay rates. I've got to average that pay rate out over the week. So they might not get any bonuses or commission, but if there's two pay rates, then that's going to apply. Piece rate earnings, as I just mentioned. So, and listen, you may never do these things. You might only do them once a year. Like, hey, if you guys this month, if you hit this number, we're going to give you guys a bonus. Okay. Like we do quarterly bonuses. We hit certain number profit. We give out a percentage of that. We spread it across. That is a discretionary bonus. So I've planned that. They've met it. They've done what they had to do to get that bonus. So you've got to include that. And now the difficult part of this, I'm going to talk about this because I've had a couple folks deal with this. If you pay a quarterly bonus or a monthly bonus, by law, technically speaking, you've now got to go back and pay any extra overtime or sick pay, which we'll talk about. Anything that this applies to, you've got to now figure out what you owe that employee for that period of time. Okay. So it makes it very difficult to have spread out bonuses and commissions and things like that, because you've got to somehow go back and calculate it. Now, our system, our payroll system, will automatically calculate that regular rate of pay, but it will only pay any overtime or sick pay or meal break violations during that week. It's not going to go back and figure out what the time is. I would love it if it did, but there's no way to do that in the system. So just be thinking about that as you pay this. And lawyers know about this. If you get caught up in a lawsuit or a PAGA claim or anything, they're going to go back and they're going to go to that regular rate of pay. And that's going to be one of the things. I'm not going to just going to throw it at the wall. Whether you even applies to your business, they're going to throw it at the wall and hope it sticks. So you got to be prepared for that. So how to calculate it's all the earnings for the week, including bonuses, commissions, divided by the total hours and including the overtime hours, right? So I'm not going to include the overtime pay so much, but the overtime hours. And then you multiply that, 1.5 or 2 times for overtime and double pay. So if I've worked, 60 hours and I got paid $1,000, I'm going to divide that 1,000 by a 60. That's my regular rate of pay. And then I can go back now and add that to the overtime. I can add the extra amount to the overtime, pay any sick pay, and pay any meal break violations with that. So I know it's complicated, but if you have any trouble with that, let us know. And again, it is applicable to overtime, sick pay, and if you have meal break violations that you pay out. And remember, that's the 1 hour lunch. So our system will do all this for you in the pay period that we're covering, but you may have to go back and do some calculations on your own. I encourage you to look at your pay system and decide what, if you need to do that. So what are best practices? Use an automated timekeeping system. If you're not doing it, please do it. Extremely important. I don't care how challenging it is. And sometimes it is because there's login issues where if an employee's out in the field and they've got their phone to log in, there are, just the software technology ramp up period. There's definitely challenges to it, but it can save you tens of thousands of dollars if you get it done right. Review all your compensation policies, make sure everybody's classified right, include all your earnings in the regular rate of pay when calculating overtime. Train your managers, payroll staff on overtime laws. And the employees need to understand too, hey guys, I don't want to pay you meal breaks. I don't want to pay you, unnecessary overtime. Let's all think about what we're doing here and make sure that they know. So definitely conduct a wage audit. Go back, even if you did this right now and you said, hey, you know what, I may have not have been doing some of these things over the last couple months. I'm going to go back and just look at it, a 6-month period or a 3-month period and see if there's anything there. And if there is, then you can correct it still. And it's a pain to correct it. I'm not going to tell you this is an easy step, but it certainly is something that if you do that now, and then say every 6 months you do you have a process where you go back and you look at those things and you record it, you document that. That can be a way that you can prevent and reduce any PAGA liability. But ensure all your overtime calculations are all correct with the regular rate of pay. Again, put managers into the loop and make sure that they understand and your payroll teams understand. and then stay updated, listen to us. And the one thing that I want to make sure that, so I know there's a lot of our clients, there's a lot of folks that are not our clients on the webinar today. We're going to do our best to help you here. We can give you the advice, we can put the tools in place, but we can't be in your businesses and making sure that you are complying with everything. We just can't. We have too many clients and too many employees to do that. So it's something that you are really responsible to do. You got to do it. We're here to help, right? So make sure that you're taking those steps. All right, so let's talk about meal and break compliance. This is a big one. This is probably the biggest thing, right, that we face as far as a lawsuit potential. And it's very easy to go out of compliance because, again, we have projects during the day, we have customers that call in, we have whatever's going on. It's really hard. Gosh, I can't take my break. I've got this webinar I'm on, whatever it is. Very hard sometimes for employees, but you've got to make it a policy within your business, make it, take the action steps to get it in place. So let's talk about how we do that. Oh, I didn't have my little thing, so you get it all at once. Okay, so why it matters? Obviously, compliance reduces legal risk. This applies to non-exempt employees under California law, and you've got to provide breaks on time or you'll face penalties. And it's not just about following the rules. There's legal pitfalls. There's problems with this. As I just mentioned, it's very hard to comply with sometimes, but it's very easy to prove, right? Whether I have electronic timekeeping or I don't have electronic timekeeping, it's very easy to prove for an attorney, right? So, and in California, this is something I heard this the other day, and it sticks with me. In California, I mean, unlike other laws, right? In our general legal system, you are innocent until proven guilty. In California, you are guilty until you can prove yourself innocent, right? So again, if you have better record keeping and documentation of these things, you're going to weather the storm pretty well of any PAGA claims or class action lawsuits. But if you don't, you are a prime target. So don't be a victim, right? So what are meal breaks? Obviously, there's a mandatory 30-minute unpaid meal break for, basically for, it has to be done by the 5th hour. And when I say the 5th hour, the minute you go to 4 hours, 59 minutes and 59 seconds and 9/10 of a second, you can't go over that. Once you hit 5 hours, that is a meal break violation. Okay. So understand that it is before you hit that 5th hour. They must be fully relieved of duties. I try very hard. If I walk right by the payroll department, if I go out of my office and if somebody they're on break, I don't even talk anything about work. I might say, how was your weekend? But I don't talk about work. Meal break can be waived only if that total shift is 6 hours or less. And that same thing applies. The minute you hit 6, you already went into non-compliance, but you must have a meal break waiver in place. We do have those. I would have every employee sign one if you have any kind of part-time employees working, and realize that, there's something in the law where you can have a blanket meal break waiver on file. But every time they request it, you want them to somehow put that in writing, like, I'm going to waive my meal break today. If you just have a blanket meal break waiver and it goes a year or 2 years and you haven't updated it or you haven't tracked it, every time they do that, you could be at risk there. So this is something that maybe you do on a regular basis when you have your handbooks done, or when, every couple of weeks or every couple of months. Just make sure that that's up to date as much as you possibly can. You can have an on-duty meal break if the employee is unable to take an uninterrupted break. So if you have a small retail shop and you have one employee working at that time, or they're on a particular construction site and there's no way for them to take a break, they can do an on-duty meal break. And again, you've got to have a document signed by that employee, and they can actually just kind of work along with what they're doing or eat lunch along with when they're working. And you can do that. So it is legal to do that, but it's got to be a very specific situation. Second meal break. So anybody over 10 hours, that is a second meal break. So once they hit that 10th hour, they're going to need a second break. Now, if they've waived the first meal break, right, I can't waive the second meal break. So if somebody works 11 hours that day, they've still got to take that break at 10. If they haven't waived the first meal break, they can waive the second meal break. Okay. So on that meal break form, you want to make sure that it mentions both. I reserve the right to waive my first meal break, and I reserve the right to waive my second meal break. We've had employees not check both off, right? So that's fine. That's up to them. That's their prerogative. But make sure that you've got that recorded. So they can only be waived if it's under 12 hours and the first meal break was taken. So again, I get ahead of myself, excuse me. Stuff's all in my brain. So make sure that is under control. But meal breaks are very, very important. It is the first, I've said this before, it's the window into your business for an attorney, right? If you are not tracking these very carefully and have a very solid policy and you have action behind it, right? Where you've paid meal breaks out, meal break violations, right? So again, I'm not sure if it's on the next slide. No, it's not. If you miss a meal break, if you have an employee's 1 minute late and you notice it, and our system will alert you, our pay system will alert you, hey, this employee is 1 minute short, or they went past the 5-hour mark. Pay the meal break violation. It's 1 hour, right? So, and it's at regular rate of pay. But if you could show any attorney or judge or anybody that, hey, listen, when we have meal break violations, we pay out the hour. Just pay it out. I know it's a pain, and some employees are notorious for falling into that trap. Just pay it. You can discipline them. You can strengthen your policy. You can put some things in place like a restriction in your timekeeping system that prevents them from clocking in less than 30 minutes. You can do a lot of things, but if it does happen, just pay it. It's part of being an employer in California. Okay, so rest break, same thing. 10-minute rest break must be provided for every 4 hours work. Now, okay, so should be in the middle of that 4-hour period. There's been some questions where clients have said, well, what if my employees come in part-time, they're only here for 3 hours? Okay, so 3 hours, not 4 hours. Should they get a 10-minute break? There's no law that says there's a limit, like after 2 hours, they have to get a break, or after 2.5. It's just got to be reasonable. If you start nitpicking, well, that was 2 hours and 59 minutes, so you don't get a break. And, just at about 2 hours or so into a shift, make sure the employees are getting a break. Okay. And make sure that it's not, I say not required if it's less than 3F. It's not, but what if they work a little bit longer? What if there's an attorney that wants to make a big deal about it, and that employee says, well, I didn't get a break, I didn't have enough time. Just don't go there. Just go ahead and make sure you give them that rest break. Don't combine it with meal breaks. That's my next one. Do not give them a 40-minute break. We had somebody doing that recently. So additional rest breaks, if they go over 6 hours, they got to get that second meal break or rest break. Employees working over 10 hours must receive 3 10-minute breaks. Again, it's going to be commensurate with how many hours they're working for the day. But definitely, but meal and rest breaks are not as easy to prove that you're doing something wrong as long as you have a policy in place, right? You're sort of okay, and you don't never prevent them from doing that. But meal breaks are the big one. So best practices, again, common mistakes: not tracking break times, or allow employees to just write them in whenever they feel like it. Allowing them to work through meal breaks without sort of the proper waivers. Like maybe they went 6 hours, but you don't have a meal break waiver in place. Failing to provide them at the required times, right before 5 hours or in the middle of the shift. Not compensating them for missed breaks. So if you've got an employee, you can do this. Hey, I got a project. I need you to skip lunch today and work through, get it done, right? You can do that. Just make sure you pay the break, right? Pay the meal break violation. Not paying violations for non-compliant meal breaks. So again, implement automated timekeeping as much as possible. I can't say that enough. Train your managers in California laws, ensure employees know their rights, and encourage compliance. Like if you guys call into our office at about 1 o'clock, you probably won't get in touch with anybody because we actually shut down. We take a break. Everybody gets to just take a break without phones ringing and emails popping through. It has made a big difference for our business, and I think it's important for the employees to not feel like, oh my gosh, I got to get back to work and do something. It's really important. And then review your payroll records regularly to catch any errors. I say do it every single week. Go back and look if there's a meal break violation. You should get an alert in our system, and you can pay that break and deal with any disciplinary issues. But definitely audit things as much as possible. And if you weren't doing this, over the last couple of years, go back and audit. And you know what? There's nothing wrong with go ahead and going to an employee and saying, hey, you know what? You took a couple meal breaks and they weren't compliant. I'm going to go ahead and pay you a couple hours. Track it, record it, and it's not that much money, right? It's not going to kill the business, and it could protect you from tens of thousands of dollars of complaints. And then seek guidance. Unsure about anything outside the box, please come talk to us. All right, so timekeeping and payroll accuracy. Why is this important? So again, I've mentioned it enough, so I won't go through too much of that. But it ensures that you're compliant. It protects the employers from wage claims and penalties, and it identifies any issues where employees need to get paid overtime, meal break penalties. Mistakes can lead to lawsuits and significant risks. Now, you're not going to have the meal break timekeeping police show up at your door, but you've got to disgruntled employees. And like I used to say, if you plan on having gruntled employees for your entire course of doing business, great. But you're going to end up with a disgruntled employee at some point, and they could take advantage if you're not doing things right. So employees expect accurate pay. Errors can lead to dissatisfaction and turnover. So if you aren't paying your folks right and there's questions and there's problems, you might have otherwise good employees that just want to leave your business. And I'm going to say, gone are the days of tracking hours and employee documents on paper. It just doesn't make any sense. Technology is so accurate. It really, really, and it's easy to use and it's affordable. So why would we not automate that? It does not make any sense to me at all. So here's some typing basics. As we said, overtime's got to be tracked, paid correctly. We've already talked about that. Meal and rest breaks documented. And employers must maintain these records for at least 3. I say just keep them for 4 years. Payroll records and actually payroll records are 4 years. I may have a mistake there. Forgive me. This was a lot of work putting into this, but keep things for 4 years. Just put it in a box. I've got a storage unit, all our staffing employees records going back 4 years, hundreds and hundreds of records files. So just keep them someplace. What you cannot do. And again, by the way, so any lawsuit that you get, they're going to go back. If they know that you've been doing something wrong, they're going to go back and they're going to look at everything. And if you can't prove those records, or if you did go back and audit those records, then you've corrected those mistakes, then yeah, you're basically on the hook for all of that. So it can be very, very expensive. So you cannot alter time records without justification and without the employee's approval. So let's say the employee was trying to clock out for lunch and it was too close to the 5 hours and they couldn't log into their phone quick enough, or their computer, or the electricity went out, and you had to put an edit, a punch. Hey, you didn't really clock out at 12:15, wasn't it 12? Well, yeah, I did. Okay, well, great. So let's edit your time card, but I want you to approve of this, right? Make sure that they sign off on it at the end. Any kind of edits that you do, don't just go through and edit those punches. Do not allow off the clock work. And that might be something as simple as, hey, can you deliver this payroll on your way home? Well, if they do that, I've got to pay them until they drop that payroll off. And like I said, it might even be just going to the mailbox, going to the post office, Office Depot, whatever it is after work. Make sure you're paying them for that time. Failing to compensate for all hours worked, including training and travel time. Travel time, that's a very complicated subject. It would probably be a whole webinar in itself. But again, if employees are driving during the day from job to job or location to location, make sure that you're paying them for that time. Those mileage, the mileage rate, the IRS mileage rate. If they come in for training, you can pay them a lower rate, but make sure you're paying them for those times. Do not round time punches anymore. There used to be rounding, and it used to be, well, we can do 15 minutes, but then we can actually maybe do 6-minute rounding. We can actually do 1-minute rounding. That's okay. California has basically come out and say there is no reason to round punches anymore whatsoever, not even to the second. Definitely meal breaks you can't do. That was already a law a couple of years ago, court case. But don't round punches anymore. There's no reason to. If they get there at 5 till, tell them do not clock in. Go get your coffee, put your coat away, do whatever you got to do, but don't clock in until you're ready to go. So yeah, no more rounding. That's done. And accurate timekeeping isn't just a practice, it's the law. Again, it's going to protect your business, it's going to ensure employees are paid fairly, and it's going to help prevent costly legal disputes, right? Stay accountable, document everything, keep it tight. All right, so we're getting sort of close to an hour. So implement electronic timekeeping. I've said that multiple times. Train employees on your policies. If you don't have a handbook, make sure you have one. If you got to put posters on the wall, hey, don't forget your breaks today. Whatever you got to do, make sure you're putting those things in place. Enforce overtime and break compliance. Make sure that they are taking their breaks and their overtime is pre-approved. It's good to have that policy in place that you get approval first. Doesn't mean you can't pay them if they work overtime without your approval, but at least you know that it's happening. Regularly audit your time records. Require manager oversight. Make sure that your supervisors are verifying the timesheets or whether in the system or not, and that they're approving the overtime. You just make sure that everybody is on board in your business with the timekeeping process. Maintain payroll records for at least 3 years. I'd say 4. Just keep everything. If you can do it even electronically, just put it into a Dropbox. Just keep it on your computer. Make sure you don't lose it. And again, that prevent that off the clock work. And again, as I said, always seek HR advice. Anything, I always look at it this way. There's a circle about this big that is all the normal stuff that we do, right? But anytime you go outside that circle, we've got to look at that a little bit more carefully. And we do that with problems here, right? Anything that we do for a client that's within that little tiny circle that's normal and there's no complications. Anything that's outside the circle, it's like, hey, have 2 people look at it, right? Let's think about it before we take action on that. So that's really important. Okay, so I got a question. I'm going to take it while we've got it right now. Does our system store payroll records for 4 years? Yes, absolutely. If you ever left us, which nobody ever does, then you'd want to pull those records out. We had a situation a couple of years ago, and this may happen with any payroll company, that if you have records in their system and you leave them and you want to go back 3 years to try to get their records, they may have moved on to a new software system and they may not have your records. It's absolutely not that payroll company's job to keep those records. So please make sure you are pulling the records for your business and that you've got them stored away somewhere. It's definitely up to you. Okay, so final paycheck rule. Get over here. So why is it important? Obviously, later incorrect paychecks can lead to waiting time penalties, and they can get very, very expensive. Ensuring compliance protects your business from wage and hour claims. Employees really rely on that final pay, so we want to be, as good as possible at that place. Waiting time penalties can be up to 30 days of that employee's wages each day. So if they make 150, $200 a day, you're up to 30 days. And I'm not talking about weekends, 30 days, right? So it can get very, very expensive. And then there's multiple penalties that will go on stack on top of that. If you didn't pay them, then their paycheck stub is incorrect, right? And so they just get stacked and it gets very, very expensive. So even accidental delay can trigger penalties. Employees can file wage and hour lawsuits for that. So let's talk about the rules. So employee quits with 72 hours notice, pay them on their last day, right? So if I say, hey, I'm quitting, but Friday's my last day, better make sure you got their pay stub, even if it's not on a payroll cycle. You've got to get that paycheck to them. If they quit with less than 72 hours notice, you can pay them within 72 hours. And again, that does include weekends. So if they quit on a Friday and you wait until Tuesday to pay them, because that's 72 hours of business days you're late. So you've got to include Saturday, Sunday, holidays. It's all included, right? So you got 3 days. If an employer terminates or lays off an employee, their paycheck is due immediately upon termination. And you may say, listen, they finish out the day, or they may be off-site and remote, and we'll talk about that in a little bit. If they can't get to your business to pick up a check, you really got to think about how you're going to pay them, right? You got to think about that ahead of time. I've got to get that employee that check today. I can't make them drive 60 miles to pick up their check if that's not a normal process for them or a normal commute for them. So think about that ahead of time. You can do, and I probably might talk about it later. I can't, I'm hoping we do. Forgive me if I'm redundant, but if it's a direct deposit, you can do a direct deposit, but you've got to get their approval, right? You must have that in writing. If you can pay them, you can send it overnight by mail. Like say, I'll overnight this to you with a signature, required, but I got to get your approval. I need your current address. Have that all in writing before you ever do that. Just don't mess with that final pay and make sure that they do get it. And again, all their wages must be paid, any accrued but unused vacation time, any bonuses, commissions that were earned, and you can calculate them. And I say earned, if I'm a salesperson and it's my job to finalize the sale and pick up a check from that client, that customer, I did a roofing job and I've got to get that check before I can get paid. You may not owe them that commission on that particular situation because they didn't follow through and finish the job, right? And they can go out there and do it on their last day if they wanted to, but so anything that's been earned, and again, by having that written commission plan in place makes it very important. And there you can spell out, hey, this is what constitutes an earned commission, and have those things very, very detailed to protect yourself for those situations where you may have to get rid of somebody. And then any expense reimbursements that are due, mileage, office reimbursement, whatever it happens to be, make sure that that you've got that all included. So best practices, what you can't do is hold any final pay for unreturned equipment or, whatever it is. I don't care if it's a shovel in their truck or if it's a computer or whatever it happens to be. Make sure that you do not withhold that. You can deal with that outside the paycheck, the final paycheck, but make sure you get that there. You can't delay it. Well, we're not on a payroll cycle. You get paid next week. Do not deduct any unauthorized expenses. So no balloon payments for loans. Don't do loans, by the way, to your employees. No balloon payments. No, you can do other than, you can do medical. You can take medical for the month out or something that's statutory, taxes, whatever, but you cannot put any unauthorized expenses in that. Best practices, prepare your final pay in advance. Make sure that you've really you got this all set. You know what you're doing. You don't just fire somebody off the cuff and then you got to go back and figure out all these steps. Use direct deposit. Make sure you get things in writing. And this is something that's come up recently. Make sure you get them their final wage statement. We've had clients that we'll send them the paperwork, and we'll send final wage statement or final wage final pay acknowledgement form. We'll send the net amount for the check. We'll send the unemployment information, and they'll get it, and they'll write the employee a check from the business, and then they'll just give them that paperwork. And even though that paperwork does detail the check, what the deductions and taxes and hours were, it's not a wage statement. So make sure that when your employee leaves or quits or you fire them, that they get that complete wage statement along with that paperwork, and that way you're complete. And then again, keep these things for, see now here I got it right. I got it wrong in the other ones. I apologize. 4 years, keep everything for 4 years and you'll be okay. So there's a lot more to talk about on these final paycheck stubs. Again, should I mail the statement? What if my employee never picks it up? There's definitely some things that you can do in that category, in that area. If an employee doesn't want to pick it up, you can try to notify them. On the second day, if they haven't said, okay, I'll come pick it up or mail it to me, then if you've got their last known address, you can go ahead and mail that to them. I would put I do it certified or do signature required or something to that effect. But at least you've done anything you can. Maybe it doesn't get there. Maybe somebody else cashes the check. I don't know. It could be a bad situation, but at least you've shown to any attorney or judge that you've done everything you possibly can to get that final check to them. So that's a very important. It's a critical part of being an employer. And real quick, so question: what if the employee has a signed agreement authorizing any deductions for pre-existing loans? So again, you cannot take that out of their final check, right? If there's a deduction for a loan, let's say they're paying you back $25 a week or a pay period, I wouldn't take it out of the final paycheck. I would just give them their final paycheck, and then deal with any balance that you've got. This is why I don't recommend you give loans to employees. We love to take care of our employees. I'd rather just, hey, you need $500 for a car. Here's $500. You pay me back in hard work, whatever you want to do. But definitely, it's a tricky area, and because of that final paycheck rule, I wouldn't take anything out of that check, especially not a balloon payment to cover whatever that debt is. So yeah, be very careful with that. Okay, we got a lot of slides to go. I'm probably going to go. So listen, I'm going to go over an hour today. I do apologize. I really try to keep these things, short. If you've been on these webinars before, we're going to go over an hour today. I think probably an hour and 10 maybe. So if you have to go, hey, you know what? No problem. No offense. I won't take it personally. We'll be sending out a recording, so you'll still get the full webinar. Okay. Hope you don't leave though. Grab another cup of coffee. We're still moving. Okay, so let's talk about. Oops, I missed one. Yeah, consult Infinium HR for guidance, please. Hey, I'm terminating somebody. I don't know how to get the check to them. They live in Arizona. What do I do? We'll take care of it. We're here to help you. That's what we do. Okay. All right. Paid sick leave and other leaves. Excuse me. So what you need to know about that, obviously, California is very, very difficult with the sick leave laws. Way more complicated. Employers they have to understand that to avoid penalties. Providing the right leave improves employee morale and reduces turnover, protection from liability. And they're growing more complex. There's new leaves every single year. We got bereavement leave now. We had our sick pay expand last year. We know that they are working on, there's California Family Rights Act that has expanded over the last couple of years. We know that it's going to keep going that direction unless leadership in California changes. It's just going that way. So just know anytime there's a leave situation, really, really pay attention to what's going on. Okay, basic rules. All California employers must provide sick leave. It accrues at 1 hour for every 30 hours worked. That's always been the same, even though it's increased now to 40 hours or 5 days. It can be used for employees' health, caring for a family member, domestic violence, sexual assault, or anything. But I'm going to stop here. You really can't question what sick leave is being paid for. Okay. So it's, once you start saying, well, my employees, I know they were off at Disneyland and they took a sick day, maybe that was the therapy that they needed, right? Maybe they're having a really bad mental health day. And for them, taking that day off is what they needed. And they use their sick time to cover it. That's okay, right? Until it becomes chronic or until it goes outside the sick pay rules, the 5 days that they get it per year, you really can't question it. And I don't recommend that you do. But once it does, then you can say, okay, listen, now you're really, really sick. I don't want you coming back to work unless I know that you're clear, that you're not sick, you're not going to bring something back into the office. We want to make sure that we protect all the other employees as well. So you can request a medical release at that point, but anything before that, don't do it. It's not worth it getting involved in that. So I don't want to pay for that. I got a couple questions real quick. One says, is email sufficient for in writing rule, or does it have to be an actual document? Yeah, email is fine. Text is fine. It doesn't have to be in writing fully, but the only, could it get technically a legal situation if you didn't have the employee's actual signature? Perhaps. Lawyers are capable of going after just about anything. So I would say just do whatever you can to verify that came from the employee, that they did approve it. It wasn't their spouse or their mother or somebody else that approved that. And can an employee pre-request a sick pay for a day off? Pre-request. Well, again, it comes down to whether or not you want to question their illness, right? It becomes a privacy issue. And, I love to take mental health mornings. I don't want to go to work. I stay home, I work out, I go for a walk, whatever. If I was an employee that got sick pay, then I may, be thinking, gosh, my week is getting really stressful. I know I've got a bad day Friday. I'm going to take 4 hours off on Thursday, and I'm going to just take care of myself, right? Self-care. So yeah. So can they pre-request it? I would say, yeah. And again, if it becomes a chronic issue, then it's a different situation, right? It's not, but a once in a while for an otherwise good employee that has great attendance, I wouldn't question it. So again, sick pay, I think, is a whole nother webinar in itself. But you can definitely, I definitely recommend that you do lump sum. If you're already doing accrual now, don't change it now. Wait till the beginning of the year, but do lump sum. Give everybody 5 days and let them do what they got to do with it. It's just part of being in California. Okay, so let's go to the other leaves that are here. There's family medical leave and there's California Family Rights Act. These apply to businesses with 5 or more employees. FMLA is for 50 or more, but California trumps that, of course, no pun intended. Provides up to 12 weeks of job protected leave for qualifying conditions, right? So the qualifying reasons have expanded. Again, we mentioned some of those in that first slide, but it could be violence, could be caring for a family member. And that has extended the who is a family member, who is a designated family member in my life, right? It might be my aunt, it might be my grandma, it might be somebody that I'm directly connected to that I could take that time off for. Obviously, there's pregnancy disability leave. You get up to 4 months leave. It can be stacked on top of CFRA and disability and all the other stuff. So that one can be very, very challenging. Definitely get help. Anna, our HR director here, is an expert in these leaves. So you want to trust her for that. There's now crime victim leave, jury duty, witness leave. As I said, it's expanded tremendously. So make sure that you are engaged with your employees when they need to take that time off. Don't dive into any privacy issues, but they should, when they request time off, they should, if it fills into one of these categories, and all these should be listed in the handbook, then you can at least inquire about that. And there's some certain things that you can do to make sure that they are taking those leaves properly. But just be really, really careful as long as it is within, within what's normal. So I'll give you that. But we'll do a webinar on these coming up soon. I'll have Anna do that. And then there's reasonable accommodations. So we've got to provide some accommodation for disabilities, for pregnant employees, religious accommodations, and victims of violence, right? So accommodation means that, if I'm a small business and I've got my key employee wants to take 2 days off a week to deal with something over a long period of time, I may not be able to accommodate that, right? Unless it falls under one of these protected leaves. I may not be able to, right? But if that same employee says, gosh, I need 2 hours off on every Thursday afternoon to go to some class or to go to some study, or I've got to go get medical treatments done, then that might be more reasonable. So whatever is reasonable, you do need to consider that. And provide that accommodation. Now, how do we do that, right? So it's called an interactive process. This is required. You've got to show that you have listened to the employee's request, that you've considered that request, and then you've either gone back to them and said, well, gee, I can do that, or I can do this with this limitation, but you've made every possible good faith effort to give them whatever accommodations they need, right? So if you can't, then there should be some reasons why, and they've got to be reasonable reasons why, right? So that comes from that discussion with the employee. Explore other options. Is there anything else that we can do? Can we shift your week? Maybe you can work on Saturday, Tuesday to Saturday, and take that Monday off, whatever it happens to be. Make sure that you're basically putting those options on the table. So best practices, and again, this can get you in a lot of trouble if you don't honor those leaves, and you prevent somebody from going on leave. They may have a real serious reason why they're requesting it, so it could become a problem. So again, what common mistakes are just not tracking sick leave, right? So make sure that they are requesting sick leave. They can do that through the app, Timekeeping app, or they're providing a form to you that you're tracking it when they do it. Denying it without a legal justification that we just talked about, and that comes through that understanding what that leave is. Failing to document that interactive process that I just talked about, retaliating them. So against them. So if an employee takes 5 days off in 6 months, that might be a lot, right? For your business, small business, it might be a lot, but it's within the law, right? So we can't necessarily retaliate against them. I can't say, gosh, you've been out, 4 times in 4 months now. Can I get a doctor's note? or, I'm going to have to take you off that shift now. I'm not going to be able to put you to work because you're taking too much time off. If they're within that protected leave, whether it's sick pay or something else, you can't discriminate against them because it could be retaliation. So very, very important to understand, all that, what's going on with your employee, and do your best to comply. So best practices, have really good policies. If you don't have a good handbook in place, please talk to us. Make sure that it's there. Use timekeeping to track everything. Again, make the employee do the work of requesting the time off, whether it's vacation, sick time, personal time, whatever it happens to be, that they're doing it through a system that tracks it for you, so you don't miss it, you don't forget it, you don't not pay somebody. Educate your managers on HR and HR staff on leave requirements. Again, is a big subject. I promise you, I'll get it out before the half point of the year. We'll do a webinar on leaves, and engage in that interactive process. And one thing I want to say about that process, I think what's really important is that you have engagement and an open door policy with your employees. You never want to have a situation where an employee is afraid to take time off because they've been reprimanded in the past, or they've seen their peers get reprimanded for time off, or you never want to have that, right? So have a flexible workplace, allow people to live their lives, right? Because we don't live to work, we work to live, right? So their lives are important. These laws help keep us all accountable, but we can always do more than what the law says by being empathetic to our employees' situation and open to hear what their issues are. I think it's extremely important. And then keep documentation of any requests. So we do have another question that came in, so I'll try to address these as we go, so we're not trying to use it for those that can't be on until the end. So if an employee does not have PTO or sick time available, can we refuse unpaid time off and still schedule them towards business needs? And if they don't show, is it considered an unexcused time off? So yeah, you can. I think you can say, yeah, no, you're required to be here. You've already ran through your sick time or your vacation time. I'm sorry, but we really need you here. This will be an unexcused time off. If you have more than, one or two of these or three of these in the next couple months, then, you may be subject to discipline or termination. Yeah, absolutely. You have the right to do that. But again, your business may need people there, all the time. If you're a manufacturing or you're a production house, whatever you're doing, your business may suffer because somebody's not there. So you've got to have some rules in place where you can protect the business as well. Just be very careful with it. And I think by having that a preset flexibility mindset, a flexible workplace, that employees have that ability to kind of work outside the legal system to live their lives. That's really important. So that's just something, yeah, you can do that. But if you have a situation that you're dealing with right now, please contact our HR office, and we can deal with that. So what about that? If they don't use sick pay at the end of the year, do we pay that out? And no, definitely not. If they don't use it, it's gone. It just basically, if you have an accrual sick pay plan, that rolls over to the next year. So let's say I accrue basically up to 8 days a year. They can use 5, and they've got 2 left over. So those 2 days will roll over to the beginning of the year. So they already start out with those 2 days, and then it continues to accrue. If you have lump sum, you give them the 5 days, and they've got 2 days at the end of the year, they're gone. You get a brand new 5 days the next year. So I hope that answers that question. And that's good. Yeah. And you can't, by the way, I'll go into this, like I said, it's a whole nother webinar here, but you can't encourage employees not to use sick pay. You can't say, hey, I'll give you guys extra money or extra bonus, or you get merit, whatever points if you don't take sick pay, because now you're discouraging them from using what's rightfully theirs, and that is their sick time. So that's important too, to understand that. Okay. Again, we'll do a whole nother, webinar on that. All right. So yeah, just protect your business, review your leave policies, train your team, implement good record keeping, and please call us if you have any issues. All right. Wage statement requirements. I'm not going to go into this too much because I know that our wage statements are correct. In the past, they have not been. We had a situation where they weren't. But I'm glad I'm not drinking chocolate milk. I'd have some on my mustache. But you've got to have everything in place. Gross, net wages earned, total hours need to be there, any applicable hourly rates. Again, if that regular rate of pay comes into place, it's got to be identified on that pay stub. Payroll deductions, employer's legal name and address. And this is a little tricky. If you have a DBA, right? So I'm, Mike's business doing business as ABC widgets, and I use my DBA on the paycheck, that's actually illegal. I've got to use Mike's business on the pay stub. And then my legal name and address, whatever that address is that you've got filed with California. Maybe you use your location address, but your legal address is some other address, your home, whatever. You've got to use that home. That employee needs to know where they can go to file a lawsuit or an attorney needs to know. So make sure that is completely detailed. So common wage statement errors, again, missing overtime rates, missing those regular rate of pays, inaccurate hours worked, not paying them on time. Those things can become wage statement violations, which then have their own penalties attached to them on top of everything else, the stackable situation. So just be careful with that. We pretty much take care of those. Our checks are legally drawn out as long as you provide us the right information, right? So if your information's not correct, go back, audit it, check it out, and let us know, and we can make those changes. And I think we'll talk about that next. Oops, sorry. Yes, there's one more question. He calls out but doesn't request sick. What is the best practice? You cannot pay them if they just request time off. They've got to specifically request sick pay, and you don't want to force them to take their sick pay. Like say, well, we just assumed you were taking sick pay, and all of a sudden the employee gets sick and they don't have any sick pay. They can now blame that on you. So make sure that the employee has, if you use timekeeping, you can have a specific request sick time off, and then that goes into the system and gets paid automatically. So what are some best practices? Hope that answered your question. Ensure all the information is included, as I mentioned, break down overtime deductions. And this is pretty tricky. This new regular rate of pay, it was pretty tricky for us to make sure that everything got on the paycheck. We believe it's correct now. So just know that's California law is just never ending, to try to get it right. Review and audit your statements. Again, make sure those addresses are correct. If they're not, and you're with us, please get it corrected. If you're with somebody else, please reach out to them and get it done. Provide electronic and paper options. So you cannot force an employee to take an electronic copy of their pay stub. You've got to give them the choice, right? You can say, hey, listen, we have electronic pay stubs. We're not giving out pay stubs this week, every single week. You can do that. But you've got to tell them, if you need a copy of your pay stub, it's here. Please let us know and we'll give you a paper copy. So I really believe in electronic, as much as possible. It reduces paperwork. So, okay, we got another 6 or 7 slides. Again, I apologize going over. I knew it would go over, and I couldn't skip through a lot of this stuff because it's just too doggone important. So please forgive me for going over on your time today. Okay, so what do we deal with employee complaints, right? So handling wage and hour disputes starts with usually an employee being disgruntled about something, right? So they can file claims through the labor commissioner, or they can go to PAGA, go to an attorney. They can try to take it internally, but like I said, they're not going to go through an attorney. So if an employee does bring any kind of complaint, I don't care what it is, just take it seriously. Do not ignore it. Do not discount it or minimize it in any way, right? Respond immediately to that employee. Let them know, hey, I got your complaint. Thank you very much. Put it in writing that you've responded, an email, text, piece of paper, whatever you got. Just make sure they know, right? The first thing is, hey, let's investigate it. Figure it out, what's wrong, keep that detailed documentation, and let's try to resolve it. Hey, I'm really sorry we missed that meal break. We missed your last 5 meal break violations. I'm going to pay you. Let's get that done. Deal with it immediately. Resolve it if you possibly can. Excuse me, and document it, right? If you do receive a PAGA notice, contact an attorney, right? You can let us know, that's great, but we're not going to really be able to assist you with that. You're going to need to go to an attorney. We have multiple really, really good attorneys that use us for payroll and HR. We've got them at the ready. So if you do need somebody and you're not sure who to talk to, we've got some very qualified labor-focused attorneys that you can talk to. Again, your business attorney might be able to help a little bit. at least in an initial response, but get a qualified labor attorney involved. So best practices for that, obviously, again, take it seriously. If you do get that PAGA notice, review it thoroughly, get to an attorney immediately, notify your key people, hey, we've got a situation. We're going to have to start, pulling information and data and go back and figure this out. Conduct that internal audit, evaluate what your liability might be, figure out what we can do to settle. Your attorney is going to help you with that. You want to reach out as quickly as possible and settle that before it gets bad. You got 33 days to respond to the labor workforce development group agency, excuse me. And then you've got to implement corrective procedures. So one of the things that you can do, so if you know you've had a problem in your timekeeping system that it wasn't alerting you to when there was a meal break issue, let's say, and that lawsuit, the PAGA lawsuit now comes through, the employee wasn't getting their meal break violations. You can do those things that we just talked about, but fix the issue, right? What do I got to do? If I don't have timekeeping, I'm going to put timekeeping in place. I'm going to take multiple documented steps to make sure that I'm now compliant. So even, that never helped before. It didn't matter. That employee had the lawsuit, you got to deal with it. But that might show a judge, that labor board, that, hey, listen, we didn't realize this was a problem and we fixed it, right? So I was able you're able to mitigate that claim a little bit, and then prepare for potential litigation. This could come up. One thing I don't know if I think we're going to talk about EPLI insurance before we get to the end, so I'll save that. And then proactively, let's prevent future claims, fix the problems, and let's deal with it. Okay, coming towards the end now. Again, thank you guys for hanging out. We had really only had a couple drop off, so I'm glad you're finding some value in this. That makes me feel good. So what's our compliance action plan? Again, and some of these may be redundant. Train your managers and supervisors. We'll have this webinar, or at least the PowerPoint, turned into a course. Make sure they know all the process. You can't create HR people out of all your managers and supervisors, but at least, hey guys, back to my circle, right? This is the circle. This is normal. No problems here. But anything outside that circle, you better come to somebody, talk to us about it, realize it, that there's a problem, and let's deal with it. Conduct regular payroll audits. We've said that. Review your wage statements. Stay up to date with California laws. We're doing our best to get this information out to you. It's really my passion. I think is helping our clients maintain compliance. Monitor changes in legislation, just what you need. Before you take any big steps, whether it's setting up a compensation plan or it's hiring a salesperson and not having an agreement in place, please talk to us first. If we can't assist you, we're going to point you to an attorney to get some help. Be sure you're working with Proactive HR Partner. That's us. If you're not working with us, then please consider it. And this is what I really want to mention, and we are going to do a webinar on this in the next coming months. EPLI, which is Employment Practices Liability Insurance. Right. So we all have insurance for fire and flood and theft and all those things, and general liability. We have those things in our workers in our businesses. But are we protecting ourselves from these kind of claims? Right. So employment practices liability insurance is not very expensive. To give you an idea, our staffing company does 3 to 4 million in payroll. That EPLI policy costs us $13,000. It covers up to basically anything after 50,000. So yeah, I'm going to be out a new kitchen, right? If we get sued, but at least I'm not going to be out a house, right? I'm not going to get sued for tens of thousands of dollars and go out of business if that were the case. So that can protect you. They don't generally cover wage and hour. All the stuff that we're talking about, these EPLI companies know California is just horrible, right? And they don't necessarily include that, but you can get a rider where it might at least provide limited protection. It might only go up to 250,000 or a million or something, whatever it is, but you get them in place. Arbitration agreements, again, we're going to include this in a compliance protection webinar coming up soon. We've got an attorney that can do these. They're going to cost about $1,000. But it puts everybody in your business, all your employees, on notice that, hey, we want you to go to arbitration, and you're agreeing to go to arbitration, except in very specific circumstances. So we'll talk more about that in the future. And remember, I've always said this: California laws don't make common sense. They don't make any sense. What makes sense to you and I and our employees, even our employees, will not necessarily make sense to California. So you've got to really understand that it's an employee-friendly state, and they're not on your side. And you just got to be really, really careful. Continue to improve your culture, your employee engagement, your communication. Just be close to your employees and provide a great workplace. That'll ward off a whole bunch of problems before they mushroom. Okay, so final thoughts. Listen, wage and hour compliance. It's not about checking off legal boxes. It's about a fair and transparent, positive workplace, right? If we could stay proactive, we can avoid these headaches, and we can boost employee morale and keep operations running smoothly. We are here to help. Please reach out to us in any way. We definitely want to be here to assist you. That's what we do. Okay. All right. So next up, questions. I think we have one question come up that I haven't addressed already. Exempt employees sick time. What if they take part of the day for a doctor's appointment? Where do you draw the line? So you can set things in place. The minimum I think is 2 hours for the day. So you can tell employees, even if they're salary, that if they're taking specific sick time related to going to a doctor, or they're sick, or something else is going on, you can require them to take that sick time. I wouldn't try to require them to take vacation. And typically, if you do have somebody's salary, hopefully they are a very significant person within your business that is very valuable. They're very, they're paid well. For me, if they have an issue going on with their family, I know they're going to get the work done, and I know they stay longer. But if you have salaried employees that are not necessarily providing you that level of service that they should be, that's commensurate with their experience or pay, whatever, then you might have a situation where that really is not a good fit to have them a salaried employee, right? Again, is it a chronic problem? Is it a one-time issue? It all depends. So I think that's important to kind of review what's going on with that salary employee. So I hope that helps. Please reach out to me directly, and if it's a specific situation, we can help you with that. So I think that was that. There's no more questions. I'll move on. I will tell you about our next webinar coming up. This will be on March 19th. We're going to bring in our recruiters. I have a staffing company here. Our recruiters are, I think, the best in the county, in the state, maybe the world. So I'm going to bring them in to kind of go through some ways that you can really hire smart. I expect it to be a good year, and we're going to grow, and we're going to hire people. So you don't want to make mistakes in that. And it's really easy to do because we all don't hire every day, right? I have recruiters, that's all they do is hire. So if you can find that kind of expertise, take advantage of it. We'll do a webinar on that next month. So check out our webpage. This is not a clickable link, our HR events webpage, and please join us for that. So thank you very much for the folks that stayed on. Again, we only lost a couple. I know this was a lot of information. I definitely didn't cover everything. So please reach out to me or Anna or anybody here for a particular situation that you have, and we'll be glad to help. Have a fabulous day, guys. Thanks for being here. We'll see you next time. Bye-bye.